Speaker.
Call Brett Hudson, 5-minute call.
Thank you, Mr. Speaker. It's an absolute delight to speak on this bill for more than one reason. One, because it's a very sensible and pragmatic bill which will help to place the victims at the heart of the justice system, which is a key priority for this government. Also because there is broad support, or appears broad support, for this bill, Mr. Speaker, across the House. And thirdly, because we all seem to think that it's the same provisions of the bill that are so positive for victims and also offenders, in fact. So if we look, for instance, to reduce the number of unnecessary parole hearings by permitting parole boards to extend the period between hearings from 1 to 2 years, or in the case of indeterminate sentences, Mr. Speaker, in fact, from 3 to 5 year intervals. Then not only is that obviously a positive thing from the victims who don't feel perhaps as re-victimised as they might do under the existing conditions of each year, but actually also for the offenders in some ways, because you could argue that coming up each year, irrespective of what progress has or hasn't been made, could actually lead to a system or a situation, sir, where some offenders or some inmates build up false hope of their real chances of being released at that point of time. And so one can only imagine, sir, that when they are unsuccessful, as the average says it's 3 hearings for each release, so as they most often are, that they quite possibly leave those hearings feeling quite quashed. And that itself is not that good for its rehabilitation. And while that is important, let me not detract from the fact that the heart of this is actually ensuring that the victims feel that they are placed at the forefront of our priorities. So the other really positive thing that I saw in this, Mr. Speaker, is this idea of relevant activities. So whereas we might be putting in place something which is going to say to inmates that the interval between your hearings is going to be extended, by taking into consideration this determined at the board hearing, these predetermined, if you will, relevant activities and milestones, there does in fact exist, or will in fact exist, provision to bring those hearings forward. So an offender or an inmate that just chooses to focus themselves on the rehabilitation services and opportunities in front of them has the opportunity to bring forward the date when they will be reconsidered again. And that surely gives those inmates hope and a real sense that they can have some control or some influence over their destiny and their time that they will spend in prison. So that, I think, is a very, very important thing as well. There are other couple of considerations that I think are very positive, and they actually return back to the victims too. So it is extremely positive to see that victims will not only be notified of the first hearing date, but they'll actually be notified, sir, of when the next date is scheduled to. So they won't be in any uncertainty. If there is an order given that it will be a 2-year time frame, the victims have the same knowledge and certainty as, in fact, the inmate does. And also of any milestone, any relevant activity or activities that might change that and bring the date forward. And that surely helps the victims of those original crimes to be able to better prepare themselves for those hearings when they're going to come up. Also, a part which I think it's fair to say probably would have come as a bit of surprise to most New Zealanders, that under the conditions as they exist today, that there is no provision for the parole board to be made automatically aware of civil protection orders that may exist. So there is the ability for the board to request information, where that information is then considered by a judge, and the judge makes a determination of whether the information, thank you, Mr. Speaker, is made aware to the board at that time. This new set of, or this amendment, these amendments will permit the boards to become automatically notified of that, which surely leads to better consideration by the boards, better judgments, better decisions, and ultimately better outcomes for the victim principally, but as I've said earlier, also actually, when you think about it, also for the inmates. So overall, sir, what I can say about this, we can talk about saving $700,000 a year, and that's always a good thing. We can talk about being very much focused on rehabilitation and the introduction of case management systems for all prisoners, the introduction of working prisons across all of our prisons to help prepare inmates for their release. But what I would like to conclude by saying, Mr. Speaker, is this bill is putting the victim at the heart where they should be, and it's a pragmatic, sensible bill that I commend to the House.
The question is that the motion be agreed to. Those of that opinion will say aye. Aye. To the contrary, no. No. The ayes have it. Party vote called for. The clerk will conduct a party vote.
New Zealand National.
59 in favour.
New Zealand Labour.
32 votes in favour.
Green Party.
14 votes opposed.
New Zealand First.
11 in favour.
Māori Party.
2 opposed.
Ag New Zealand.
1 in favour.
United Future.
1 in favour.
Members, the ayes are 104, the noes are 16. The motion is carried.
Parole Amendment Bill, third reading.
Call on Government Order of the Day number 3.
Objection of publication and